Good afternoon and welcome to the Children and Family Affairs Subcommittee meeting February 17th, 2026. We're going to begin with Chairman Boso leading us in prayer. Please stand and remain standing for the pledge, please.
Heavenly Father, and the Son, and the Holy Spirit. Heavenly Father, we ask your blessing on all of Tennessee's children, especially those who are most vulnerable. We ask your blessing on their parents. Give them the patience and the discipline to raise the children in your ways. And we also ask your blessing in a special way on this committee, that all the laws that we enact will be to protect and support our families and never to harm them. We ask all of this in the name of your Son, our Lord Jesus Christ, who reigns with you in the unity of the Holy Spirit, one God forever and ever. Amen. In the Father, and the Son, and the Holy Spirit.
I pledge allegiance
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Members, have we all checked in? Are they all in?
No, we'll have the clerk open the board. Yeah.
Clerk, would you please open the board? Madam Clerk, would you please take the roll, please?
Madam Chair, you have 4 members present. You have a quorum.
Thank you, Madam Clerk. Today, we're going to have a presentation from the Second Look. But today, so first, we have 5 bills on the calendar. So we have a little housekeeping to do. House Bill number 1, House Bill 2270 by Representative Hicks has been rolled 2 weeks. Number 3, House Bill 1845 by Representative Butler has been taken off notice. So we will go back up to number 2, House Bill 2078 by Chairman Farmer.
Motion. Second.
You're properly motioned and second. You're recognized.
Thank you, Madam Chair. First off, I want to congratulate the committee for having an adequate sized hearing room. I remember when I was on a Children and Family, we could barely get around that small one over there. So I don't know what you did to get the upgrade, but it worked.
Maybe it's because you're the chairman. I don't know.
Probably. Yeah, since I'm not on here anymore, you get a bigger room. Okay, I see. But yeah, members, I have a bill up today. It also has an amendment. The amendment has just a cleanup. It broadens the definition of threat of harm of the children, just kind of opens it up there to protect these children even more. So
do you want to put that on?
Yeah, if we get that on there, it's a non-substantive type deal there. So
okay, all of those in favor of adding amendment 013206 on to House Bill 2078, please say aye. Those opposed, no. It's on the bill. Chairman Farmer, you're recognized on House Bill 2078 as amended.
Okay, members, what this bill does, if there's a situation where there's allegations and there's a crime charges brought to some parents, say, for example, if there's a child that's left the home and they made some allegations that the parents had wronged them in some way in a criminal fashion, and there's minor children in the home, if those parents are arrested and their bond conditions put against those children from being around the parents, what this bill does would allow for or require that a hearing be conducted within 15 days, and that the government would have to prove through clear and convincing evidence that those children that are still residing in the home are in harm's way or in threat of harm. Now, we do this in other hearings like orders of protection. So if someone has an order of protection against them, it's required that a hearing be conducted within 15 days. We're putting some guardrails on this just to be sure that these children aren't taken from the home we want to be sure that if they're removed from their home, that there's good reason to do so. So that's what this bill does.
Are there any questions for Chairman Farmer? Representative Keesling, you're recognized.
Call for the question.
Question's been called for. Is there any, all in favor of, okay, I messed up again. All right, we're ready to vote. All of those in favor of House Bill 2078, vote yes, and all those opposed, vote no. Has everyone voted? Does anyone want to change their vote? Seeing none, Madam Clerk, would you take the vote, please?
Madam Chair, you have 4 ayes, 0 nays.
Chairman Farmer, your bill moves out to judiciary full,
Thank you, Madam Chair. Members, always a pleasure.
as amended. Okay. Okay, so we're going to give Representative Keesling. There's no amendment on it, is there?
There is amendment for this. So if it doesn't have a motion.
Okay, are we okay? All right, now we're down to item number 4, House Bill 2082. Got a motion? Good, we do have a second, Chair Lady. And so we are, let's see. Would you proceed in presenting House Bill 2082? Thank you.
Thank you, Mr. Chairman. This bill prohibits a parent's or legal guardian's action of raising, guiding, or instructing the parent's or legal guardian's child consistent with the child's biological sex, including referring to the child by titles or pronouns consistent with the child's biological sex, or making mental health or medical decisions based on the child's biological sex, including consenting to any lawful medical or mental health service to assist the child in living consistent with the child's biological sex, and declining any medical or mental health services for the purpose of gender transition for being the basis for any of the following.
Okay.
So the intent of this bill is to make sure that the child makes no serious decisions about their biological sex until they're 18 and can make those decisions on their own.
Thank you, Chair Lady. And that is an overview or an explanation of the bill. We're going to have to go out of session. We do have some testimony today, actually by 2 folks, as I understand it. So let's, if there's no objection, we will go out of session for testimony. And first up will be Lance Kinzer, I think. I hope I pronounced that, Mr. Kinzer. Is that right? You're, again, just for the record, just again, state your name who you're with, and proceed, sir.
Yes, sir, Mr. Chairman. Lance Kinzer, Kinzer, First Amendment Partnership. And thank you very much for the committee for hearing me this morning.
Forgive me for interrupting, Mr. Kinzer. We got 3 minutes here.
Yes.
You understand. Thank you.
Yes,
I'm sorry.
absolutely.
Yes, go ahead.
So as the chair lady already indicated, the core purpose of this bill is to make it absolutely clear that unlike has occurred in other states, no child will ever be removed from the home. No parent will ever have a child in need of service. There's a complaint made against them. There will never be a criminal action for abuse or neglect taken against a parent, and no parent will be disadvantaged in a custody determination simply because they intend to raise their child consistent with their biological sex. Section 1 and 2 of the bill deal with raising a child consistent with their biological sex around the issue of abuse or neglect claims in the civil context against a parent. Chapter 3 deals with criminal abuse or neglect claims, and Chapter 4 deals with the custody situation that I talked about before. I think the core way to look at this bill is that it's really simple. It stands for the proposition that parenting that affirms a child's biological sex is not abuse or neglect. We can all agree that the state should step in when there is real abuse, when, as current Tennessee law puts it, a child suffers a wound, injury, disability, or physical or mental condition caused by brutality, neglect, or the use of force. But we're crossing a very different line when loving, involved parents are treated as dangerous simply because they do not believe in current trends in gender ideology. And that's especially the case as the science increasingly shows that children who are not encouraged to socially transition, to use alternate pronouns, to breastbind, to do other things, this kind of social transitioning, that the vast majority will ultimately move back to feeling comfortable with their biological sex. And so it's not abuse, rather it's good, prudent parenting to say, let's slow down, give these kids an opportunity to develop before they make these important decisions. And the bill really is absolutely clear, and this is just the final point I want to make. The bill is absolutely clear that it does not change the definitions of abuse or neglect in any way. It absolutely leaves leeway to the state to step in situations where that's appropriate. It just provides that normal course parenting consistent with biological sex is never abuse or neglect under Tennessee law. So thank you very much.
Well, thank you, sir. Thank you. And just remain right there in case we have questions to Mr. Cosner. Any questions from the committee? I see none. I hear none. Thank you, sir, very much. I appreciate it. Next, we have Nanette Clark. Would you come on up? And again, the routine is the same. Name and who you're with, please.
My name is Nanette Clark. I'm an attorney here in Nashville. I have been a child advocacy attorney for a little over 30 years over in juvenile court. The thing about this bill is parents in Tennessee have very broad rights, and the government should not micromanage our families in Tennessee. The government should not create new laws that could cause harm. Tennessee should not pass laws that expose our state to a very expensive litigation. The question is not whether parents have authority. They have authority. The question is whether the state of Tennessee should immunize conduct that will hurt a child. You have to address the best interest of the child, and this bill does not allow that to happen. Suicide risk among transgender youth dramatically rises in the environments of rejection. Child welfare already evaluates emotional abuse, not just psychological abuse. Tennessee law currently allows courts to intervene when a parent's conduct or custodian causes demonstrable psychological injury. This bill allows psychological injury. Additionally, in Chapter 1, Part A, if this bill is passed, it says should be amended to state this shall not be a basis alone, and amended from must not be a basis to shall not be shall not be a basis alone. We don't use the words must in the juvenile court section 37. This bill also prevents courts from considering identity basis humiliation, forced outing, or coercive conduct as emotional abuse. It removes the safety valve for our most vulnerable children. And regarding unruly, if you change that just because a child disagrees with a parent, we are going to have so many children in the court system. It's a very slippery slope. Generally, just because a child is in mere disagreement that a parent does not fit the definition of an unruly child. This is a legal risk to Tennessee. We need to limit the risk of litigation. This will cost Tennessee litigation dollars. We must consider the federal Equal Protection Clause, First Amendment, compelled speech issues, forcing a child to use pronouns or denying thereof. You are forcing a person or minor to use a specific pronoun or deny that. You're denying their First Amendment rights. This exposes the state to lawsuits.
Ms. Clark, 3 minutes. I'm sorry.
Okay, thank you.
Okay, thank you. Thank you for your time. No, stay right there. There could be some questions, please. Are there any questions from the committee to Ms. Clark? I see none. Thank you very much, ma'am, for your time. Appreciate it. All right. I don't think we're going to, if there's no objection, we will go back into session, and we will now turn our attention to Mr. Harris, Representative Harris. Tori, you're recognized. I see that there is a an amendment coming, and would you please give us, and would you give us the drafting code, please?
Awesome. Yes, thank you, Chairman. And then the drafting code is 013451.
Perfect. That is correct. Do we have a motion and we got a motion and
Motion.
a second? Do we have a second on this? I see none. So the amendment fails, of course, and we will move on. Chair Lady Littleton, we will now draw our attention back to you if you have any closing remarks on House Bill 2082.
Thank you, Mr. Chairman. I just asked for a positive vote.
She asked for a positive vote, so we will see. All right, here we go. We are ready to vote. Those in favor of House Bill 2082, vote. Or those opposed, vote. Clerk, would you please give us the results? Okay.
Mr. Chair, you have 3 ayes and 1 nay.
Okay, so House Bill 2082 passes. And it moves on to judiciary. All right, we will move on to item number 5, again by Chair Lady Littleton. That is House Bill 2083. Chair Lady, you are recognized.
Thank you, Mr. Chairman. This bill raises the, in 2017, the General Assembly passed a bill to establish 5 safe baby courts throughout the state. The purpose of the baby court program is to reduce the incidence of child abuse, neglect, and endangerment, and minimize the efforts of childhood trauma or state's more vulnerable population. Since then, we have continually expanded the program, and 3 are now 22 fully operational baby court sites, and more which will be operational this year. This bill extends the eligibility to families with children 5 years of age or younger, rather than those 36 months or younger. This expansion allows for counties who are not operating at capacity to reach a broader group of children, maximizing the effectiveness of the state funds by serving more children. The priority will still be given to the families with children under 3 years of age.
Thank you.
Do we have a motion second?
We got a motion. Did we get a motion and a second on this? My apology. We did. We got a motion. Yes, we did get a second. I've seconded. Okay. Any questions to Chair Lady Littleton on House Bill 2083? I see none. I hear none. So we are off to the races. We're going to vote those in favor. Well, there you go. I'm so used to going back. All right. Vote them up. Clerk.
Mr. Chair, you have 4 ayes and 0 nays.
Thank you. The motion passes, and it is moving on to judiciary, full judiciary. Okay, with that, we'll go back out of session. Gavel will go back to the chair lady, and she'll be.
I think we're out of session right now.
Okay.
So now it's just-
Thank you. So today we have Kylie. She's going to come up and talk to us, Kylie Grace, about the Second Look Commission. I've served on this for several years now, and she's going to tell you more about it. But I've learned more about child abuse and how that we can go about trying to help the families and save more of the children's life through this program. So it's a sad thing that we have to do, but I think you can't say you enjoy it at all, but it's something that I've been honored to be a part of. So just give us your name and who you're with, please.
Yeah, absolutely. Thank you for having me, Kylie Graves. I work for the Tennessee Commission on Children and Youth and serve as the director of the Second Look Commission. So the Second Look Commission is established in statute. It is administratively attached to the Commission on Children and Youth. However, for all other purposes, it is an independent commission. It is a multidisciplinary team made up of 17 different individuals who are experts in their field. And the task for the Second Look Commission is to review an appropriate sampling of cases involving a second or subsequent incident of severe child abuse in order to provide recommendations and findings to the General Assembly regarding whether or not severe child abuse cases are handled in a manner that provides adequate protection to the children of the state. And so our findings and recommendations shall address all aspects of child abuse investigating, including but not limited to reporting, investigating, and referring of alleged severe cases, the risk severe child abuse victims of being returned to the custody of the child's abuser or being placed by the state in an environment where the child is at risk of being abused a second time, procedures used by courts, alleged prosecution of alleged perpetrators, causes of severe child abuse, and any preventative measures, and the manner in which severe child abuse data is collected, and then the representation provided to victims. So I think you all have a document that will have some of our case data, the number of cases we've seen over the last year, and our membership. I'm going to jump straight into our findings and recommendations from this year, just in the interest of time. So with that, we like to start out with some of the strengths or things that we've seen well, things that we'd like to duplicate. In one instance, we felt the Department of Children's Services had taken all reasonable steps, and there likely was nothing more it could have done to prevent the child's death. Members acknowledged the efforts the department made to keep the child with their family, including arranging early intervention services and referring them to the relative caregiver program. We have quite a few findings and recommendations throughout the report. On the slides, you'll see everything that we've covered. I'm going to, as I'm recapping, just hit a few of them, but if you have any questions about those in particular, we can definitely dive into those. So, oops. One of the things the Commission repeatedly sees is need for additional training on child abuse and signs of child abuse for pediatricians. Members identified a need for additional training on recognizing and reporting signs for medical professionals, and then also greater public awareness of the 10-4 FACES P rule, which is an acronym used to help identify potentially abusive bruising in children under 4 years old. Additionally, one of our specific notes was members noted that a young child who had been experiencing steady weight gain then gained almost no weight for a year between annual visits. Members felt this could have been one of the first signs of neglect, and had intervention been initiated, it might have saved his life. So for recommendations around training, the Second Look recommends an investment in education for all medical professionals on training and child abuse indicators. And then in 2025, Tennessee recognized October 4th as 10-4 Day, which is a significant milestone in child abuse awareness. Second Look recommends continuing to recognize 10-4 Day annually and establishing funding for community education initiatives. When talking specifically about abuse death investigations, the Second Look Commission receives a list of cases from DCS every year. It's about 1,000 cases per year. We pull a random sample with the exception of all the abuse death cases we will review. That hovers between about 2 to 8 per year, but we always look at the abuse death cases. When we reviewed abuse death cases, members noted that a child's autopsy revealed healing rib fractures, which were not addressed in the abuse investigation or linked to a cause of death, and there was no documentation showing that these fractures were investigated further. Members also discussed the significance of the term child torture and felt it should be used when a case meets that clinical definition to accurately reflect the severity of the abuse that occurred. For recommendations around abuse death investigations, members recommended defining child torture in statute in line with the clinical definition used by providers. For access to healthcare, members emphasized the importance of educating individuals about and providing access to voluntary long-acting reversible contraception, and also prioritizing that initiative to the 5 counties with the highest rate of substance-exposed infants for educational opportunities. When looking at evaluation for familial placements, members observed multiple cases where children remained with grandparents or other relatives despite repeated maltreatment allegations. And it was noted that in non-relative homes, the child would have likely been removed under similar circumstances. Members reiterated the need for relative caregivers to receive support comparable to that provided to foster parents, including the full daily board rate, access to respite care, insurance, and social support. For recommendations around relative and kinship care, there needs to be greater assessment and supervision of non-custodial placements. And then prior to making that placement, there should be a clear understanding between the department and the caregivers regarding what support and services will be available to them. And then additionally, a federal rule change now allows for separate licensing for kinship placements. And this new licensing, if the state pursued it, would allow the state to use federal funding for the relative caregiver program. And if those federal funds were being drawn down, it would the children would have easier access to Medicaid coverage. For no contact orders, visitation, and custodial decisions. Although a mother was permitted to have supervised visitation, she was unsupervised with the child at the time of the child's death. And members continue to see cases where children are harmed while in the care of individuals who have existing no contact orders. Additionally, members pointed out that the caregiver who was present at the time of the child's death had a history of aggravated assault, and there was question why this criminal background wasn't addressed until after the child's death had occurred. And so when we talk about contact orders, visitation, and custodial decisions, although judges are responsible for making custody determinations, the quality of those decisions depends on the completeness and accuracy of the information that's presented to court. And so it's imperative that all known details regarding caregiver suitability, including any safety concerns, risk factors, are clearly communicated in order to ensure informed and appropriate judicial outcomes. Then looking at the safety and treatment of children inside residential facilities, some of the findings by the commission, members strongly felt the need for additional accountability and transparency regarding the treatment of youth while placed by the state in a residential facility. Both children and staff at a residential facility corroborated allegations that staff improperly restrain youth during therapeutic holds, resulting in injuries, the reported injuries including broken bones. Members had significant concerns regarding the practice of therapeutic holds. It was discussed that the holds are being used too often incorrectly and with heightened emotions, and they're resulting in injuries and a death. Members discussed the need for de-escalation training, but also a complete reevaluation of the use of therapeutic holds in facilities. Members noted recurring instances where staff provided children with substances or exposed them to sexual content and conversations while in care. Staff at a residential treatment provider corroborated allegations that they served children food with maggots in it, and in several instances, they are served food with mold or spoiled milk. Allegations that staff members at a residential treatment provider antagonized children, bringing up their trauma in front of others and sending them into crisis were corroborated by both children in the facility and other staff members. The Second Look Commission has significant concern regarding the treatment and conditions of children placed in residential facilities throughout the state. In response, the commission recommends that the comptroller undertake a comprehensive audit of all residential facilities housing children, giving their oversight authority and capacity for independent evaluation. The comptroller's office is uniquely positioned to conduct a thorough assessment and address any systemic issues identified. And additionally, the General Assembly should undertake a comprehensive evaluation of the current oversight structures and mechanisms governing residential facilities that serve children in state custody. Strengthening oversight is essential to ensure the safety, well-being, and quality of care provided in these settings. Around autism spectrum disorder, members noted that a child was given a self-diagnosis of autism, but it was normal behavior for a maladaptive environment. And so there should be consideration that these may be normal adaptive behaviors to a non-ideal or traumatic situation. Additionally, children who have experienced severe abuse are sometimes misidentified as having nonverbal autism when their silence may actually be a trauma response. And so if autism is to be considered as a factor in a child's case and a basis for decision, there needs to be a formal clinical diagnosis by a qualified professional. Members expressed concern about the number of psychiatric medications prescribed to a 12-year-old child diagnosed with bipolar schizophrenia, and prescribing them to a child with a known history of noncompliance was considered highly risky. Second Look Commission recognizes the critical need for integrated healthcare services for children in foster care. An ongoing shortage of accessible services for youth remains a significant barrier to care. So the Second Look Commission continues to recommend expanding access to mental health treatment and providers across the state. And then similar to autism, if conduct disorder, oppositional defiant disorder, or conditions like ADHD are going to be used to inform case decisions, there should be a documented diagnosis by a qualified professional. Members noted in many child death cases, the family's first contact with the department was due to substance exposure at birth, and they questioned what ongoing services or supports are available to parents or caregivers after a child is born substance exposed. Tennessee's seen measurable success in improving improving outcomes through Safe Baby Court, and so Second Look Commission recommends continued expansion of Safe Baby Courts to serve more families. Additionally, stable housing is a cornerstone of recovery and family unification, yet many caregivers with substance use disorders face significant barriers to securing safe and affordable housing. So the Second Look Commission emphasizes the urgent need to expand housing opportunities tailored to this population. When looking at prosecution, members continued to express concern about the lack of prosecutions, stating that while the statutes are strong, they are not being enforced consistently through legal action, and also noted the difficulties in obtaining data on child abuse prosecutions, particularly when those cases are resolved through plea agreements. For child abuse statute, in several cases reviewed by the commission, strangulation occurred. Members discussed whether strangulation alone should be a factor for severe child abuse. And then additionally, when hotline calls report that a child over the age of 13 is sexually active with an older adult who's not in a caregiving role, those cases are screened out as not falling under DCS jurisdiction, and they're referred to local law enforcement. And this creates a gap where children do not receive forensic interviews or support services. So members suggested including statutory rape as a trigger for forensic interviews could address this issue. And then members again reiterated the importance of anonymous mandated reporting. In one case, multiple people around the child prior to the death had noted frequent bruising, including black eyes, bruising on the ear, and facial bruising and cuts, and these individuals did not make a report. So for recommendations around the child abuse statute, Second Look recommends amending the code to include strangulation as a severe abuse offense and as a factor for aggravated child abuse, and then also recommends legislation that would require law enforcement to refer statutory rape cases to the Child Advocacy Center for a forensic interview and for that case to be staffed by the appropriate child protective investigative team. Around sexual behavior and findings, the Second Look has reviewed several cases in which parents permit or facilitate sexual behavior in their children who are below the age of consent, including children as young as 11. For runaway youth, it appeared as though a child's repeated runaways were not properly documented. Although a child ran away from custody around 8 times, only 2 incident reports were filed. And then over the course of their time in custody, a child ran and was trafficked or sexually assaulted on the run at least 5 times. The final time they trafficked another child and now are potentially facing criminal charges as a trafficker. Second Look recommends that the department and contract agencies adhere to the protocol for reporting runaways, absconders, and escapees by filing an incident report as soon as possible after a child runs away. And additionally expressed concern that a child with a well-documented history of being trafficked was now potentially facing charges as a trafficker. Members felt there was missed opportunity to protect them and prevent this outcome. They also recommended that in such cases, district attorneys carefully consider an individual's prior victimization before pursuing criminal charges. Regarding transition homes and offices, a child with a history of being trafficked and possibly recruiting others ran away from a facility with a younger child. During that time, the older child trafficked the younger one. Upon return, the older child was placed into a transitional home with other children. In some cases, a child's placement ended with the stated reason planned. Updated assessment indicates placement and/or level change. but there was no evidence that an assessment had actually been conducted and the child was placed into a DCS office or transitional living home. A child reported using methamphetamine while staying in a DCS office. This is the second time that the Second Look Commission has seen a case where a child with a history of trafficking another younger custodial child to run, or convincing a younger custodial child to run and then trafficking them, has been placed into a transition home immediately upon return. There needs to be an established protocol for instances like this that ensures the children are secure and not at risk of further victimization. After a child disclosed using methamphetamine while in a DCS office, the only documented actions were the child surrendering the substance, undergoing a drug test, and having their belongings searched. Members that noted no further follow-up or investigation was recorded. They recommended that in situations like this, a formal investigation should be conducted, including a documented process to ensure that other children in the office were not exposed to the substance. Members noted that despite 10 years and 19 investigations, the child was never taken into custody. In one case, a child received numerous services, but their home environment remained unchanged. Members emphasized that the failure was not in the services themselves, but in repeatedly returning a child to a home situation that had not changed. Members noted that there's mechanisms in place to keep children safe. They just need to be more consistently followed. When a child is at imminent risk of harm, they need to be removed from that situation. If there's an assessment conducted, that needs to be used to inform decisions and actions moving forward. And then finally, a Second Look Commission recommends adding representation from the Department of Mental Health and Substance Abuse Services to the commission, and also adding language to our records access statute, clarifying that residential treatment providers and agencies that contract with DCS are subject to and must comply with Second Look Commission requests. I know that was fast, but happy to answer any questions y'all might have.
Members, do we have any questions? Representative Alexander, you're recognized.
Find it.
Okay.
First of all, can you tell me what happened to the little kid that got trafficked by the older kid? Because you mentioned what happened to the older child, but you didn't mention what happened to the younger child. Did they ever find him?
I don't want to say too much just to make sure I'm not giving anything that could identify. The child is receiving services.
Okay, yeah. Thank you for that. You had something else you said here. One moment. Oh, under child abuse statute findings, top one, you said, in several cases reviewed by the commission, strangulation occurred. Members discussed whether strangulation alone should be a factor of severe abuse.
Yeah, so it is arguably with severe abuse. Oh, was that?
Well, no, that, to me, when a child gets strangled by a parent, that's abuse. But I guess there's a difference between severe abuse and abuse.
So with that, it's more so commission recommended specifically naming it. In theory, strangulation would fall under severe abuse. I don't have the definition right in front of me, but part of severe abuse is an action taken that would inflict significant physical harm or something. You could argue that it is, but the commission, seeing the correlation to strangulation and fatal outcomes, wanted strangulation specifically named and called out. Arguably, it is already severe abuse under the idea that you're inflicting significant harm with the intention of, I can't remember the exact definition. So it's more so just specifically clarifying that if strangulation occurs, it is automatically severe abuse.
Okay.
You could probably argue that it already is.
Okay. All right. Thank you very much.
Thank you.
Are there any other questions?
Oh, yeah, thank you.
Chairman Bolso, excuse me. Did
Thank
you
you.
have another question?
No.
Okay.
No, I'm
Okay.
finished up. Sorry.
Okay.
Thank you, Chair.
You're recognized. Sorry.
Thank you, Madam Chair, and thank you, Ms. Graves, for that excellent report. I just have a question about two of your legislative recommendations.
Absolutely.
One was to revise 37-1-102A28 to provide a definition of the term strangulation. And why is it in particular that it would be helpful to have strangulation as a defined term in the code?
So with that, strangulation is defined in the code. Our recommendation was to use that defined code and add strangulation as defined in, where was it? But using the established defined definition in code and just saying if this act occurs, it's child abuse or severe child abuse. Does that answer your question?
It does. It does actually more than that, but
Okay.
it prompts another question.
Mhm.
And I don't
Chairman
want this to
Bills-
be, thank you.
Let me say this, we are adding it to the codes this time to make sure
Ah.
that it is completely defined, so
Okay, thank
sorry
you.
for the
No,
interruption.
that's helpful, Madam Chair. That'll
Yeah,
let me
you're
go on.
recognized again then.
That'll let me go on to my second question.
Okay.
Because there was also, Ms. Graves, a similar recommendation to modify 39-15-402 to provide a definition of, quote, child torture, close quote.
Mhm.
And I'm interested to know what would be helpful about adding a definition of child torture to the code.
Absolutely. So that one we are actually not including in the second look legislation that's going forward. We spoke with legal, and there's already a grave torture statute, which might cause some confliction. The main difference between that is with child torture, there might not be the intent to kill the child. The act is just being done in torture. Grave torture does require the intent to have homicide occur. But what we've seen is these incredibly severe cases of abuse where it's prolonged, systematic. There's psychological components and physical components to it, which is what medical professionals use. There has to be multiple instances, and there has to be both the occurrence of psychological abuse and severe physical abuse. And so we had a case where unfortunately the child did pass away. However, there was some discussion of, had that child not died, what would be the appropriate offense? And at that point, I think it would have been aggravated child abuse. So we were just looking for something a little bit more expansive for those kind of most severe, most heinous cases.
Thank you,
Thank
Madam
you.
Chair. Thank you, Ms. Graves.
Thank you. And Chair Lady, I did want to say Christian helped me out, or it was either someone came up, it was either Christian or Jim. So right now, severe child abuse has a definition of exposure of a child to serious bodily injury or death, or the risk of serious bodily injury or death caused by brutality, abuse, neglect, or use of force. And so you could argue that strangulation kind of fits in there, but we just wanted it explicitly named. Thank you.
And
Thank you.
we really thank you for being here. And I do want to say that we all need to be on the lookout for children that are being abused, and malnutrition. We see that a lot.
Mhm.
And somehow it's not picked up by the doctors or by the neighbors, and severe bruising as well. So
Mhm.
let's all keep our eyes out and open, and let's all be aware of children that are in need of homes, good, safe homes to go to. And a lot of times we see the homes that are kinship, or, that sometimes they're worse than the home they were in to begin with. And they kind of play smart at the beginning, and then they turn out to be worse than the home that they were taken from.
Mhm.
So let's just be aware of our children that are out there and do everything that we can to save them. Because our little motto here is we want to save them all, but if we can do it one at a time, that's what we need to do. So are there any other questions for Ms. Colley here?
All right. Thank you.
Seeing none, thank you so much for being here. We
Thank you. I
appreciate it.
appreciate it.
So without objection, we'll go back into session. Without objection, we are adjourned.